Hello, my name is Muhammad Asad Yunus and my student ID is 210300653. Today I am going to demonstrate my presentation for the assessment 1 of company law. So the making of companies and corporation is basically to form and to regulate the business. So this is the very common and this is the very formal way of conducting the business and controlling the business as well. So there are different so many benefits of this way of joining the business. So there are some flaws and there's some um, disadvantages through the way people taking some advantages for making the money for illegal ways. So I will discuss the both things in this presentation, and the questions which are mentioned in my assessment question. So I will throw the deep light on all the questions, and I will try to mitigate all questions. So the success of a business largely depends upon the compatibility between the purpose of conducting business, such a business, and the form of business set up to achieve it. Yet there are inherent advantages specific to each business structure, where sole proprietorship benefits the absolute control over the business. It is, on the other hand, vulnerable to closure upon the death of the sole trader, where partnership helps in accumulating the talent, wealth, and time of the partners. On the other hand, it imposes the liability upon the act of one partner in the course of business. Notwithstanding the strict statutory requirements for the corporation structure, one inherent benefit that makes it stand out from other business structure is the legal segregation between the business itself and the members who have invested therein. Unlike sole leaderships and partnerships, the corporation is in law a judicial person. So its perpetual existence is not dependent upon that of its members. Furthermore, any loss is to be borne by the corporation and not members. What the members may lose at the maximum are their shares. What members may lose at the maximum are their shares, personal assets, protection benefits outweighs may of the disadvantages of the corporation business structure. The separation of members' finances from the corporation stem from the corporation's separate legal existence and personality. Consequently, this reduces the financial vulnerability of the members of corporations. It is only the value of members' shares in the corporations that may be lost or by him. Corporations' obligations do not bind the members. When it is said the corporation's personality is discrete from its members, then it implies the following liabilities and rights of corporation with others separate from its members. Corporations survives the death or insolvency of any of its members' perpetual existence. Certain entitlements of natural persons are available to the corporations. Basically, the corporations and the companies are assumed to be a legal person. They have a separate legal entity. In this regard, it is assumed that the company can be sued and can be sued by itself, but company is not a person in actually in a physical form. company can't act by itself. So any act done by the in part of company, that must be done by its mm, is running is management and is the executive bodies of the companies. So this is the general rule. Members of the corporations have only limited liabilities. Exceptions, there are some exceptions of this general rule. The limited liability of the members may be denied in some instances. Implication: the exceptions to the limited liability rule implies that one, the court discovers the presence of any such instance, the member responsible for it shall assume the liability of the corporation for the purpose of redressing the grievance involved. Limited liability of such members or more remain limited. This is legal. This is legal parlance. Variedly terms a lifting or piercing the corporate veil or shield. So it exposes the insider members. The difference between lifting the piercing was discussed in the case of Stoughton's LJ in Atlas Maritime Co. So and Evelyn Maritime Limited in 1991. This instance involved the piercing of corporation veil are not limited to the common law grounds, those arising in the judicial decisions, but also rampant in the statutory grounds that are made punishable under the law. The common law grounds, as led in Adams' case and invoked in a number of subsequent decisions, for instance, Stones and Rolls versus Moore Stephens in 2009, and Beckett Investment Manager Group versus Hell 2009, and the Competition Commission 2013. And the facts property, basically the whale and the can be the whale can be pierced and lifted in different cases which are shown, but the general rule is that the corporations have different entity, and the members of or outsiders have limited liabilities in their companies. So generally this can't be lifted, but there are some exceptions in case of for example in case of injustice, unfairness, and the facet sham, agency, fraud, and group in price. Stone versus Rolls Moore Stephens 2019, and Beckett Investment Manager Group versus Hell. So these all exceptions were exercised under the company law section 1993, the fraudulent trading, and section 1121 officers in default, and section 251 when the shadow director act any misconduct, and all these things are exercised. This is the only discretion of the court when the anything prima facie looking wrong. So the terms used in Latin in this regard is res ipsa locator. That means the things speak itself, and things look like there's prima facie wrong. There's any hidden. The directors hide something. The director did not expose in front of shareholders and the other members of the board. So then the court can uh, go ahead these limitations to go across the general rule and exercise the exceptions. Um, so the but the fact was behind these cases, the property was transferred by the defendant to the company he formed, in which the shares belongs to him and the clerk only. This was done to avoid being compelled for specific performance. Court decisions specifically perform ordered not only against the company but also the defendant. The rationality in this judgment, in this decision, is since the corporate body was but a mask for the defendant, whereby he attempted to avoid the obligations already assumed under the contract, the transfer property to the purchaser. And the other fact is the Hone, who was the director of the company, was contractually debarred via trade restraint provision. So a competing business was set up by him. He his wife and an employee were the only shareholders and the directors of the company. So the decision is the prohibitory injunction were granted by the court. Rationality in this case, in order to avoid the contractual obligation after leaving the company, a new setup was formed in defiance of such obligations. So the competing trade restraint. Therefore, court, instead of treating the corporation body separate from its members, pierced the veil and obliged Hon to honor the pre-existing obligation. A corporate setup may be purposely formed to hide the nefarious actions for the members of the company. In such situation, the piercing the corporation veil becomes a necessity then. So fraudulent misrepresentation by the director of the company entails personal liability. So deliberately committing fraud behind the disguise of corporate body is a valid ground to pierce the veil and make the fraudster liable alongside the corporation body. The existence of an agency relationship between the corporate body and the member is relied upon in many English case of piercing the corporate veil. This exception is very restrictively employed, and the court, before piercing the veil, satisfied itself that the company in fact was nothing but acting in the capacity of an agent of its members. Company can't be act by itself. This is the main thing in this. But the mere injustice cannot be sufficient for such piercing. Sansom was allegedly running one member company to evade tax. The court did not consider the law concerning taxation at all. Rather, court considered the agency concerned. The corporate veil was not pierced and Sansom was not held liable. This was because of the absurdity to assume by piercing the corporate veil that loan was made to the Sansom and not to the company. If we talk about when we talk about the UK corporate and company law, there is three more significant statute which are discussing in this regard. So the first is the UK company law 2006, and the article of association, the memorandum of association, the model articles. Section 3 of company law hints at the limited liability of the members of the company. It distinguishes between a company that is limited from the one that is not limited. The limitation as evidence in the constitution of the company may be in terms of shares or grantee. The limited aspects refers to the liability of the members of the company, in that is but restricted to what has been agreed to. As such, in a limited liability company, the personal assets of the members of the company are protected. But the section 16 of the Companies Act 2006 underpins that once a company is registered, it gets all the entitlements being a distinct legal person. As such, it can buy property in its own name, can enter into contract in its own name, can sue and reciprocally can be sued in its name. Being a separate personality at law, it is viewed separately from its members. As such, its liability varies from that of its members. Liability of a company is to be redressed out of company assets and not um, the assets of its members. Uh, Even after the lapse of numbers of years since the first time when the corporate veil was pierced by the English courts, till date, no precise, clearly and adequate yardsticks has been adopted. So there is an imperative need for a uniform standard to regulate the judicial piercing of a corporate veil. Much has been written and debated, but of no avail. Still, the debate exists, and major development is needed. This is because of a severity of consequences that arises between the court reject the piercing of corporate veil or where it ordered, but the veil is to be pierced. In the light of the years that have passed, the lesson learned is that leaving the issues to judiciary is not going to end the debate. Broader the room is for the exercise of discretion is such an important area of company law. The more obscurity shall stem therefrom. The legislative intervention is a viable option whereby a standard may be laid down, binding all the courts equally. The judicial decision is in the past, and the reasoning employed therein may be taken up a guiding rule during the drafting formulations. It is not the economic but the law that courts deals with. Principally, corporation is distinguishable from its members. As such, the rule is not be abridged. From a corporate veil is placed only as a very restrictive, equitable remedy. EVN principle and concealment principle, only two exceptions to limited liability rule. McNay in the same case did not agree with Sumpton's J, and because he held that restricting the scope of application of corporate veil piercing shall exclude the possible future grounds. Separation of corporations from its member is still same as that of when it was laid down in Salmon versus Salmon, albeit the turbulence arising from the ambiguity surrounding the limited liabilities rule and exceptions thereof. The Salmon rule finds greater global relevance even today. Still, the courts are reluctant to compromise the presidential rule laid down in the Salmon case. Notwithstanding the considerable criticism, the Salmon rule signifies remained uncompromised and unimpeached. An exhaustive enlistment of grounds of piercing the corporate veil is, for example, moving away from the Salmon precedent is not possible. Piercing the corporate veil subject to jurisdictional discretion. Clarifying and limited the exceptions are essential for impairing unambiguity in this art of business law. So this is my presentation. Thanks.